Hello there and welcome to this employment law update from Pure Employment Law. My name's Nicola Brown and today I'm going to be talking to you about pulling a sickie and the Metroline and Ajaj case. Now, pulling a sickie or malingering is unfortunately something that most employers will have to deal with from time to time. There's all sorts of reasons why employees might take a sickie, from the Monday morning hangover through to perhaps needing time off for a job interview or wanting to take time off to care for children and not wanting to take it as unpaid leave. So it is something that does fairly frequently arise, and I think this case will be of interest to employers because it deals with whether an employee who claims to be sick when they're not or who exaggerates their symptoms is actually committing an act of gross misconduct. So I've put a link to the judgment here for anyone who wants to have a look at it. The case was actually decided in 2015, but the judgment was only released fairly recently. So let's take a look at the facts of the case. Firstly, Mr. Ajaj worked for Metroline as a bus driver. He'd actually worked there since 2004, so he was quite long serving. In February 2014, Mr. Ajaj suffered from an injury due to slipping on some water on the floor of the toilets at work. He obviously was off sick following that accident, and as a result Metroline referred him to occupational health, who examined Mr. Ajaj and concluded that he was not fit for work. They referred him for some physio, but because of the concerns that Metroline had about the genuineness of the accident and his symptoms, they arranged for some covert surveillance to take place. The surveillance footage led Metroline to believe that Mr. Ajaj was exaggerating his symptoms. They therefore referred him for a second medical examination, which took place in April 2014 and was followed by a review meeting with Metroline. They also arranged for further surveillance to be undertaken, and obviously throughout this time Mr. Ajaj was unaware that the surveillance was happening. At a review meeting on the 24th of April 2014, Mr. Ajaj told Metroline that there had been some improvements in his health, but he described some ongoing problems, such as the fact that he could only do very light shopping and couldn't walk very far or for very long. At that point, Metroline confronted him about the surveillance information. They showed him the surveillance report and video footage and asked him about the apparent inconsistencies between what he was describing and what he appeared to be doing in the footage. They suspended him on full pay pending a disciplinary procedure and then subsequently followed their disciplinary procedure. It appears that Mr. Ajaj's main line of defence was that the footage must have been altered. At the end of the disciplinary process, Mr. Ajaj was summarily dismissed for gross misconduct. Metroline gave three reasons for his dismissal. Firstly, that he had made a false claim for sick pay. Secondly, that he had misrepresented his ability to attend work. And thirdly, that he had made a false claim of injury at work. Mr. Ajaj appealed using the company's internal appeal process, but that appeal was rejected. Mr. Ajaj therefore brought Employment Tribunal claims for unfair dismissal and breach of contract. Now, at the Employment Tribunal, the tribunal agreed that Metroline did have a potentially fair reason for dismissing Mr. Ajaj, i.e. his misconduct. They agreed that he had exaggerated his symptoms. However, they went on to conclude that a reasonable employer would have considered Mr. Ajaj's actual duties and whether he was capable of fulfilling those duties. The tribunal found that the medical evidence showed that Mr. Ajaj was unfit to carry out his duties, so therefore he had not made a false claim for sick pay. There was also no evidence in the Employment Tribunal's opinion to suggest that he had lied about the accident having taken place. On that basis, the Employment Tribunal decided that the dismissal was unfair, but gave a 35% reduction in compensation based on Mr. Ajaj's contribution. The tribunal obviously felt that he had been dishonest, but not dishonest enough for it to amount to gross misconduct. Now, Metroline were obviously not happy with the tribunal's decision and decided to appeal. At the Employment Appeal Tribunal, it was found that the tribunal had not applied the test correctly by focusing on whether Mr. Ajaj was capable of performing his duties. Mr. Ajaj's capability was found to be irrelevant to whether he should be dismissed for misconduct. And the Employment Appeal Tribunal referred to the landmark case of BHS and Birchall and said that that was the correct test to be applied. BHS and Birchall is one of the most famous cases in employment law and gets referred to very frequently in cases involving misconduct. So what is the Birchall test? Well, firstly, the employer needs to have a reasonable belief in the employee's guilt, and secondly, that belief needs to have been formed based on a reasonable investigation. Separately, the decision to dismiss also has to fall within the band of reasonable responses. What the band of reasonable responses means is that not every employer will come to the same conclusion about a particular offence, and what matters is whether that employer's decision falls within a range or band of what reasonable employers would do in the circumstances. In this case, the Employment Appeal Tribunal said that the dismissal was fair. This was because pulling a sickie was dishonest, and that was a fundamental breach of contract which entitled Metroline to dismiss Mr Ajaj for gross misconduct in the circumstances. And I've put a quote from the case judgment here. An employee who pulls a sickie is representing that he is unable to attend work by reason of sickness. If that person is not sick, that seems to me to amount to dishonesty and to a fundamental breach of the trust and confidence that is at the heart of the employer-employee relationship. This is a quote from the judge who sat alone and heard the Employment Appeal Tribunal case. I think this is interesting because Mr Ajaj didn't pretend to be ill in the strict sense that some people do when they pull a sickie. Instead, he exaggerated the extent of his symptoms, and it seemed clear from the medical evidence, at least according to the Employment Tribunal, that he was still sufficiently unwell that he couldn't have fulfilled his duties anyway. I can understand the Employment Appeal Tribunal's position here because obviously there was dishonesty, but I do wonder whether the decision would have still been the same for a one-day sickie for someone attending a job interview, or perhaps somebody who had a day off and claimed to be ill when it was actually the case that they were looking after their children. I'm not suggesting those things are not dishonest, but I'm not sure that most people would consider those things the same level of dishonesty as someone who lied in the longer term about their symptoms. However, this is the current case law on this subject, and so let's go on to look at what the learning points are from the case. So what are the points that employers should take away from this case? Well, firstly, pulling a sickie or exaggerating symptoms is dishonest, which I'm sure will not be a great surprise to you, and can be gross misconduct. Covert surveillance can be justified and used as evidence, but shouldn't be the norm. Now, the whole question of covert surveillance of employees is a topic for a separate update really, but suffice to say, employers will need to have specific reasons or suspicions to justify carrying out covert surveillance, particularly on employees who are not at work. It certainly shouldn't be something which is done routinely, so it is always best to take advice if you're thinking about doing this. In practice, I'm sure that most employers won't have the time or resources to justify carrying out surveillance on lots of absent employees anyway. It's important that employers don't jump to conclusions. We are seeing more and more cases where employers are being presented with information, perhaps obtained from social media, which might suggest that somebody is pulling a sickie. It is always important to carry out an investigation before jumping to conclusions, and that investigation could include getting some medical advice. That investigation will also form part of a fair procedure, so if you're dealing with something as a disciplinary matter, that procedure is going to be absolutely crucial. Thank you very much for listening. I hope you found it useful. This was our first employment law update of this style, but we hope there will be some more coming soon. If you do have any questions, my contact details can be found via our website and the links here on the page for you. We specialise in giving practical plain English advice, and we offer a free initial chat to all potential clients, so do feel free to get in touch. We offer a free monthly employment law e-bulletin to keep clients and contacts up to date, so you can subscribe to that via our website too. Thank you very much for listening.